specifically with the order, with the injunction says, is that he's not restricting any prior restraint on
the judge wanted to make,
Judge Kirsch.
Yeah, wanted to make very clear they didn't want to do that. So.
Correctly. And then Judge Woodruff was the one applying the order later. And that what happened is that in the restraint of speech is that he has simply cited to an article or referenced an article, even on his own Facebook page, he references an article, right? And so the First Amendment permits him to do so unless there's some criteria that apply. And what the courts have said, well, that if you're going to restrain speech, there's got to be some standard. And that if you're going to restrain this type of speech, because you don't know what a person may or may not say or what they may or may not cite to. They may cite to some different article that references political activity of some type. And in this particular case, some of the issues that are in this article are addressing whether the district attorney's office is handling activities which are better handled by civil courts or not, whether time could be better spent prosecuting one person as opposed to another.
Doesn't that article contain statements made by your client for which your client had been previously sanctioned?
No, sir. My client was previously sanctioned for delving back into the records that he was restrained from using.
Well, what
and
about
that was the prior criminal contempt. So the prior criminal contempt addressed accessing the database, which he was prohibited from doing.
But
so that was the prior criminal contempt.
Wasn't there an agreed order where your client was found in civil contempt for communicating via fax with the spouse of one of the employees of the accounting firm here?
There was a agreed civil contempt that addressed my client contacting 3 people, 2 employees, and physically going to the office of the wife of Mr. Walters.
And so here, instead of going to the office, he's sending a fax to her.
In one particular count, there was a fax sent to her office.
And you're saying that's free speech expression there?
Well, in that particular count, and I said to the court, that's the one that's the most potential for a harassment argument. And in that particular count, it went to it looks like from the record that these faxes went out generically to several people. And one of the businesses that received it was someone within that office who then took it to her.
So were there any non-clients of the accounting firm that got these faxes? So non-clients plus the spouse, were there anyone else that got these faxes from your client?
Well, it looks like there may have been some friends that then went and told, and I'll address that issue because it's a good question. The restraining order restricted him from harassing Blankenship, CPA, employees, agents, etc. Right? And that what the court did is there's a Facebook post that he's found criminally account 10 days in jail for a Facebook post. Doesn't go to anybody. That's his own opinion to look at this article. And then, for instance, Judge Stranch from the Sixth Circuit and Charles Bone appeared to be acquaintances of some type, who then relay the information back to Blankenship. And so these are people outside of the restraining order. And so the question, and what the judge, aware that this is an issue, and that these aren't the people in the restraining order, how can he be found in criminal contempt for the public at large finding out something and relaying it back to people within the restraining order? And the case law is real clear. It's Hogue versus Hogue. I've cited it. They haven't said that's not the right case, or that somehow you can expand the individuals within the restraining order to anyone that may then, and what the judge says is, hold up, I'm going to apply a reasonable foreseeable standard, which is new. And then there's no case law that they've cited that says you expand the people within the restraining order to anyone that may be reasonably foreseeable to then pass it along to someone who may then pass it along back to the people within the restraining order. So it's an exponential expansion of the individuals that are covered by the restraining order. And what Hogue says is, no, this has to be strictly construed. You don't by implication expand stuff like this. It's like a penal statute. It's construed in favor of the person that's charged with the essentially criminal contempt. And that in this case, I have said, well, if it is constitutionally not a First Amendment issue, that the expansion to these individuals is improper. For instance, Ms. Walters, there may be an argument, and they have made the argument, well, maybe you should be more careful to make sure her company didn't get this somehow. Should have done a better job of screening out people who got the email. As to the Facebook post.
Well, I think the clear implication of the hearing here is that your client specifically singled out Ms. Walters for this fax.
That's the one I say submitting we're the most vulnerable on. That's different. There's 4 counts he's found guilty of, or 5, and one of them is a Facebook post or his own Facebook page. So now we've gone from a Facebook page, not toward any.
So in your opinion, it's not harassing someone if you send out negative information to their clients and other people about them. It's not harassing them.
The harassment, and I'll just waive my time and answer this.
No, you're free.
Go ahead. You can answer my question.
Well, you'll still have rebuttal.
Thank you. One person's harassment may be another person's informing people of what happened. And so the definition of I'm being harassed, and what this is basically, this is a accounting of what has happened. Now, should he be told, well, you can't ever speak about what's happened. You can't speak about your criminal conviction. You can't speak about the fact that you think the district attorney was doing things that he shouldn't be allowed to do. That, by definition, I don't think is harassment, specifically if you post it on your Facebook page and you're citing to an article. There was no finding.
But saying X person has committed crimes and sending that out to acquaintances or having that available for and you know it's going to get out to their clients and friends and whoever, that's not harassment.
Well, the article is referencing a prior affidavit that was signed before this ever happened. So the affidavit to the regulatory board, it's on in this article on page 4, I believe. So this isn't him currently shouting from the rooftop. They're going back and reading what the allegations were made.
Well, yeah, it is currently shouting from the rooftop. How can you say that? You're broadcasting it out to the world.
Well, this is about something that had already occurred.
It doesn't matter.
Well,
in my opinion, I don't see what difference it makes whether it was something new or something old.
Well,
why isn't it harassment? That's why I'm asking, and you're saying, well, because it's old. Well, you bring up convictions of people and other things that people do, have done in the past. Now, I don't understand why that wouldn't still be harassment.
Well, in this particular case, in this individual that wrote the article goes back historically and writes what has happened historically in this case. Now, our client, by posting it on his Facebook page, the court has says, well, that is and or to people that aren't covered by the restraint. In other words, he is completely muzzled about talking about this case forever for fear that the court may say, well, what you're saying about this case is harassment and you can go to jail. So there has to be some finding that it was defamation to constitute the harassment under the modern rule. What the modern rule says is that the fact that it's unpopular doesn't do it. There has to be a prior finding that it's defamatory. And then you're told you can't repeat this defamatory behavior. There's no basis for it. If you do, you're found in contempt of court. That's what the Tennessee law is in this situation. Otherwise, the risk is that you so muzzle free speech that no matter what you might say, the concern is, the chilling effect is, people are scared to speak out.
Okay, I get
That's
it.
the issue.
Thank you.
Thank you, Mr. Crawford. We'll hear from you further on rebuttal. Mr. Hooper? Good morning, sir.
May it please the court, I'm David Hooper of Brentwood. I apologize for my tardiness. I represent Blankenship CPA Group. It is important as to how we got here. This is a long-going legal battle that initiated back in spring of 2016. On March 31 of 2016, there was a temporary injunction hearing with Judge Kurtz, who put down a temporary injunction that said, among other things, there are many other different issues here dealing with theft of data, use of data, those kinds of things. But with respect to what we're here for today, paragraph 4 of that temporary injunction said that Mr. Wallick would be restrained from making threats towards or acts of extortion or harassment against Blankenship CPA Group or its principals, employees, or agents. 6 months later, on December 9th of 2016, Mr. Wallick was held to be in civil contempt for emails that Judge Binkley, who was then handling the case, said represented a total disregard and disrespect for the orders of the court based on the emails that were presented that Mr. Wallick had generated. He held him in civil contempt. That's contempt number 1 for harassment. Contempt number 2 generated in September of 2017, 10 months after the civil contempt finding, when Mr. Wallick sent text messages to 2 employees at Blankenship. But more importantly, for this case, he did 2 things. He hand-delivered to Judy Walters, the wife of one of the principals of Blankenship, who is the manager in the Dixon office and who was Mr. Wallick's former boss, a document that was derogatory towards the firm, towards Mr. Walters in particular, and suggested that they were under investigation with the Board of Accountancy. And then he also chose to send Judy Walters a private Facebook message. I will say parenthetically, I have no idea how you do a private Facebook message, but he did. And he sent it to her, and she got it at dinner that night, and it contained the same references that had been in the writing she had received at her office that had been hand-delivered to her office earlier that day. That led to a filing of contempt petition that had 2 legs. One was criminal for the data usage that was prohibited, and the other was for civil contempt for the harassment. After he was found guilty in March of 2018 of the data usage and was sentenced to jail and went to jail, on July 24th of 2018, Mr. Wallick entered an agreed order of civil contempt in which he personally, not just his fine lawyer, but he personally agreed that his contact with Judy Walters had occurred and was in willful disobedience of the temporary injunction and was a violation of that temporary injunction, and specifically dealing with that area of the injunction in paragraph 4 that said that prohibited him from threats or acts of extortion or harassment against Blankenship's, its principals, its employees, or agents. So by his agreement, whether the court found it or not, until he agreed, he acknowledged my contact with Judy Walters, the wife of Mike Walters, is violative of this temporary injunction, and I transgressed. Let's come forward to 2020. And on August the 20th, he sent a fax, a 9-page fax to Judy Walters. That was this article that was Stephen Wallick's incredible journey regarding Blankenship CPA Group. There were no pictures on it because it was a fax, but instead it had the text of this article that was an online article, and it added not only the old saws that he had been using regarding her husband, his dealings with clients, suggestion of lack of independence by the accounting firm, tax fraud and other things that involved clients who were named and who are local. One of them was the president of a bank in Dixon. The bank itself was alluded to, but it also involved Ms. Walters' personal financial matters, not just the mortgage on her house and where they lived and who they lived around, but also that they were building a new house in a new community and the mortgage and who held the mortgage on that house. But it also dealt with her mortgage on her real estate office in Dixon and referred to that by the client of the firm that had loaned them the money, a lending institution that had lent them the money to build this house. On that same day, the same fax was sent not only to her, but to dedicated clients, meaning a dedicated fax, was sent to these clients of the firm who immediately started calling Mike Walters, Ms. Walters' husband, who was the manager of that office in Dixon, and they start sending him these faxes. Again, same thing for them. And one of them who contacted him was the gentleman who was accused of tax fraud, who's the president of the bank, and as Mr. Walters testified, a very serious sit-down conversation occurred after that with Mr. Walters, the client, and C.J. Blankenship, the managing member of the PLLC. About a month before, on Facebook, there was a posting by Mr. Wallick that said, everybody, it's got a picture of him, he's on his Facebook, everybody, please share this. We've got to get the word out. This is the only way we can stop this corruption. And he has a hyperlink with a picture of him and his family, as I recall, on the Facebook page. And the hyperlink is to this online posting. The online posting that was accessible then by Ms. Walters, who saw it, by Mr. Walters, the members of the firm, and others, the public at large, included not only the online article as had been faxed to Ms. Walters and clients, but also posed pictures of Mr. Wallick, his wife, and their young daughter in a pleasant picture.
Did the article contain any information that for which Mr. Wallick had been sanctioned before, or is it just the contact?
I submit that he had been sanctioned for it because he had been sanctioned for it back in December the 9th of 2016 by Judge Binkley for the emails that he had sent out that had contained comments, derogatory and defamatory comments. And then later, when he contacted Ms. Walters in 2017.
But on Facebook, I mean, so this contained a link to an article that was on the internet, right?
That was on the internet,
Right.
yes, sir.
So anybody could access that article if they search for it.
Anybody could have, but the difference is here that Mr. Wallick went out of his way to post it and suggest on his Facebook, everybody.
I'm
please
assuming
share this.
Blankenship CPA does not. Do you follow people on Facebook? What do you do on Facebook?
I
I'm
don't-
sure that
I
they're
don't do
not
Facebook.
friends on Facebook.
They're not. It was publicly.
So they had to go out of their way.
Someone contacted as Ms. Walters testified at this trial, someone contacted her as she was driving back from being in Florida and she accessed it on her phone because they alerted her to it, and she was upset, as you might expect.
But it sounds like, I mean, we're getting a little far afield here, what's in the temporary injunction when I mean, I don't see anything about internet posting, anything of that nature. I mean, direct messaging, if that's a thing in Facebook, I don't know, is one thing. But just posting something on Facebook, really?
Well, the thing of it is, and this is where I believe that Judge Woodruff looked at it, that Mr. Wallick, embraced the article,
Well, of course he's going to embrace it. I mean,
because he was the one who supplied all the information.
Yeah, he either supplied the information or wrote it himself, or I don't, or ghosted it for this other gentleman. I don't know, but of course he's going to embrace it.
Well, the difference is, and Mr. Blankenship in his testimony made this point, unlike standing on the top of your roof and saying derogatory things about your neighbor next door, or standing on the sidewalk and yelling at him with a bullhorn, we do that now by social media. And not all of us do that, but many people do. Most people are involved with social media, and you are responsible for what you say. You need to be responsible for what you say in the modern day bullhorn on the sidewalk, which is social media. When he said, everybody get this out, this is the only way we can stop this corruption. I'm going to fight these guys, and I am fighting them. I can afford to fight them. And then he links it to this hyperlink that created its own derogatory effect against, not against so much the non-protected parties, but the protected parties. It was intended to stir Blankenship, and it did.
But it sounds like to me in this case, the problem lied in the fact that people went out and searched for this Facebook post and found it and did a little more research. At some point they were taking it on themselves to have that negative consequence. I mean, they basically fell in this gentleman's trap, it strikes me.
So if you fall into a trap, for whom did he set the trap? And he set the trap for Judy Walters, for Mike Walters, for Blankenship, for everyone at
Maybe they should stay off Facebook.
That's maybe wise, and that would be the kind of thing I would tell my
Or at least stay off his his page or whatever you call it.
But when they are contacted and said, you need to see this about what Steve Wallick has said about you and Mike, and they texted to her.
I think the response then should have been, no, we don't need to be doing that.
That's one choice. However, there is a choice that was not made by Charles Bone, nor a choice that was made by Judge Stranch.
Well, that's a little different. I mean, Mr. Bone, I'm assuming, did not solicit the facts. And so the facts, I agree with you, are a different subject, but the Facebook post.
He got an email, and Judge Stranch also received an email to her email, and I don't know if she was physically located in
those strike me as
Cincinnati.
designed to harass. I agree with that. But the Facebook post, I mean, it just strikes me as a different animal.
Well, we might respectfully disagree about that, and certainly Judge Woodruff found it to be, because he so went out of his way to stick the knife in the wound through Facebook, that it was inappropriate in his judgment.
Going back to my question to your opposing counsel here, was there any inquiry about the connection between the author of this article and...
There was no proof in the
Okay,
record.
no one thought to ask if...
Well, or no one needed to ask, because Mr. Wallick was quoted at length, and he supplied all the material, whether Mr. Wallick generated it or whether this guy was just going through the internet and said, hey, I bet I could write a good article about Steve Wallick. It really doesn't matter, because it's what Mr. Wallick did with the article that was harassment. It was not the publication of the article. We didn't sue that guy, but we came back against Mr. Wallick for harassment for what he had done. They make 3 articles. I will hit them very quickly. The first is that Mr. Wallick was found guilty for criminal contempt for exercising his constitutional First Amendment rights. We strongly disagree. Those acts for which he's held in contempt are non-protected acts. He reached out toward Judy Walters. He reached out towards these clients. He sent emails to Charles Bone and to Judge Stranch, because he chose to do it to get at Blankenship. There is no prior restraint involved in this. He was told you can't do acts of threats, harassment, or extortion, and he did it anyway. And in fact, he repeated what he had done with Judy Walters and did it again. The second argument they make is that the court improperly expanded the application of the temporary injunction to include Ms. Walters and also friends and family or friends and clients. Judy Walters was already included by his own acknowledgement as being off limits. Whether he agreed that she was a member of the protected class or not, he did acknowledge, which I maintain is the same, that she was protected and he had transgressed by violating the agreement and the injunction. The last thing is there are findings and conclusions that we've tried to identify that do not require a remand. The court can make the decision based on what you have. I think that the judge gave appropriate findings and conclusions as we cite in the record. Thank you.
All right, thank you, Mr.
Yes,
Hooper.
sir.
Mr. Crawford, your rebuttal.
Thank you, Your Honor. And in this particular case, there are different counts involved in that we acknowledge on the one spectrum is Ms. Walters, which is one that we were most vulnerable in discussing, and on the other spectrum is the Facebook post. And we had strongly argued at the trial level and would again urge here that that type of activity is not within the restraining order.
Do you concede that contacting Ms. Walters was a violation of the restraining order?
I don't think the evidence showed, in our opinion, that it was an effort to contact Ms. Walters, that was an old fax number that the company had. They no longer used much.
Didn't he direct message her?
No, he's going back to the prior activities. And so in this particular case, what happened is a fax went out to several people, including, she runs a big real estate company. There's an old fax number. Someone didn't have her name on it, didn't say Judy Walters. Someone within the company got it, came to her and said, hey, this came on the fax. So we don't believe the evidence showed it was an effort to specifically give it to her. It may not have been that she was screened out as thoroughly as she should have been, but that it's not the same situation where he'd gone by her physical location previously and dropped off a package. So that's not the same activity. As to Judy Walters, though, however, and whether this reasonable, foreseeable standard should be the law in Tennessee and an injunction, I think bears some discussion and consideration by the court. And my client has done things which trial judge, everyone's upset about, understandably. But the issue is when you have an injunction as written and the people being harassed allegedly, right, or factual, or the stuff may have been inappropriate to talk about, does it have to be toward these people, right? And that's what the case law seems to indicate. Now, what the judge said, and there's no citation for authority to support it, and no citation by the counsel here to support it. Yes, that's true, Mr. Crawford, that those people aren't in it. But we're going to say that we're going to use a reasonable, foreseeable standard. In other words, the four corners of the injunction no longer control. And that I would leave that for the court's consideration. That's the whole case. It's very, very specific that these type of statutes have to be strictly construed. And I don't believe the reasonable, foreseeable standard is one this court has ever adopted. And so I would urge the court to even though these facts aren't the best facts, sometimes bad facts make bad law, right? But that legal finding from the Court of Appeals, I would urge the court to consider. As to the finding of fact and conclusions of law, I happened to be here earlier today and listened to some of the arguments, and the court's quite accurately stated, well, the court speaks through their orders, right? And their findings of fact and conclusions of law. What the defendant has done is cited to back and forth between counsel and the judge during closing argument, and asserting that this back and forth somehow constitutes findings of fact and conclusions of law. And it simply doesn't. That the courts are charged in a bench trial to make specific finding of facts and separate conclusions of law, and it's just simply not present in this case. And that would, either this court has to plow through it and try to figure it out, or needs to go back for those findings. Thank you.
Thank you, Mr. Crawford and Mr. Hooper, for your arguments. You've given us a lot to think about, and we'll take the matter under advisement. Before Mr. Crawford and Mr. Hooper leave, I want to thank them. Their case was to have been argued yesterday because we were hosting the Tennessee Bar Association boot camp. We had planned to have 3 cases so that you would get your CLE credits and what have you, and we had to continue one case on the motion of the party, one of the parties, for meritorious reasons. And when that happened, I asked our staff attorney to reach out to Mr. Hooper and Mr. Crawford to see if they could accommodate us today, and they both said yes. So thank you on behalf of the court and the Tennessee Bar Boot Camp for being here. You are free to go about your business, but you're also welcome